Hello. Okay, so it's about time we read Weiss's Concise Trustee Handbook, a guide to the administration of an express trust under the common law, functioning under the general law merchant. Let's read that again. A guide to the administration of an express trust under the common law, functioning under the general law merchant by Carlton A. Weiss. Second edition, 2008. For private educational use only, this book is published with the understanding that the author and publisher jointly, severally, are not engaged in rendering legal, accounting, or other professional advice. All decisions made based on the material in this book are ultimately done at the discretion of the reader. Author and publisher jointly and severally assume no liability whatever. Published by Negotiations, Analysis, and Contractual Relations Specialists, NACRS, in care of Golden Powers, Las Vegas, Nevada. Okay, so it says over here, page 1, contents. Here's the introduction. Page 1, trust basics. Page 2, express trust under the common law. Page 2, declaration of express trust. Page 4, the trust corpus. Page 6, certificates. Page 8, trustee basics. Page 10, powers and duties of the trustee. Page 11, privileges and liabilities of the trustee. Page 13, authorized representatives. Page 16, express trust versus corporation. Page 17. Understanding commerce, page 21. That would be a really good one to start with. Doing business, page 24. Limiting liability and risk, page 26. Banking, that's a good one. Page 27. Transferring assets, page 29. Issuing certificates and bonds. That sounds good. Page 32. Keeping minutes, page 34. Prevailing in legal affairs, page 34. Maintaining proper IRS relations, page 41. Conclusion, page 43. And sample forms, page 45. So the introduction, this handbook is about the administration of express trusts created under, I don't know how to scroll down on this thing. This handbook is about the administration of express trusts created under the original American states, i.e., example, the general law merchant. As it stands in 21st century America, the material presented herein has been reduced from various sources, which the reader is encouraged to examine for his own knowledge and further understanding. The material herein has been rendered into a concise handbook format, intended to allow the reader to refer to each section for guidance on decisions regarding the most pertinent aspects of the administration of an express trust. So only secondary attention has been given to all other matters. All in all, the author's objective by this handbook is to devise a simple guide with clearly outlined methods and sample forms for the effective handling affairs of express trusts, while also showing the many options for growth and prosperity and profound protections afforded by express trusts when created and administered properly. This book is written in a somewhat unconventional manner in order to accommodate this objective. If the reader should find after examining the sources that this work has failed in its objective, then let it be attributed to a fault of the author, not to any supposed faultiness of the sources or the express trust itself. It will be admitted by all honest and learned lawyers, as it once was when a lawyer by definition was learned in the law. Okay. Down here, this little footnote says that the general law merchant is embraced under general common law. Example, the original and unique system of commercial law in the American states, in which there is no commerce regulation of express trusts except in connection with income derived from corporate stock and physical franchises under Article 1, Section 8, Clause 1 and 3 of the Constitution. C. William A. Fletcher, The General Common Law, and Section 34 of the Judiciary Act of 1789. The example of marine insurance, 97, Harv. L. Rev. 1513, 1514, 1984. 2. It was the strongly held belief of U.S. Supreme Court Chief Justice Warren E. Burger that 75 to 90% of all trial lawyers are either incompetent, dishonest, or both. Oh, that's good. See 102 reports of the American Bar Association, 205, 206, 1978. Page 2, Weiss's Concise Trustee Handbook. Ugh, this thing is so touchy. That the express trust, especially one created with proper care to its instruments, is a far superior form of security or organization in general for individuals who desire to exercise their natural rights. Trust basics. Here we go, folks. First, it must be understood that any trust, regardless of the many designations applied to them, is in its most basic sense a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. The classification applied to a trust is based primarily upon its mode of creation, in which it may be created either by act of a party or by operation of the law. In the case of the former, trusts are divided into two types: express or implied. So over here, creating a trust. It's too touchy. Well, if we look at the chart over there, it says creating a trust and the arrow goes down. It says by act of the law. And it goes resulting and constructive. Then over to the right, it says by act of a party, implied or expressed, oral or written. So when you express a trust, you say it out of your mouth. This is a trust that's being administered, or you write it down. So without getting into the various subclasses of express and implied trust, the basic difference between one created by express act of a party and one created by implied. See over here, there's one that's created by express act of a party and one created by implied act of a party, is that the former is stated fully in language, oral or written, while the latter is inferred solely from the conduct of the parties. So the way they act, interesting. These are very generalized definitions, so presented for want of space, since there are many intricacies concerning the true meaning of the term implied, it has been shown that a sense, the classification of express trust, can only be applied based on what is implied by the language of the instrument which created the trust. 5. So we won't get into that. Our focus is on a particular written express right here, trust type. And even though the above definition is essentially accurate, it does little to define the express trust as it is known in its fullest sense under the protections of the common law. Express trusts under the common law. The most adequate definition of the express trust is to be understood from the earlier case law, which has been eloquently summed up and restated into a clear, concise definition by Alfred D. Chandler, Esquire. That means he was a lawyer. In a report submitted to the tax commissioners of Massachusetts on unincorporated associations. Ooh, unincorporated. Yeah. That means it's not an LLC, it's not a subcorp, it's not a corporation. It's unincorporated associations. His study was conducted as part of a legislative investigation into their economic field or economic effect on the state in 1911. In the first part of the report, at pages 6 through 7, he offers the following definition. Express trusts put the legal estate entirely in one or more persons, while others have a beneficial interest in and out of same, but are neither partners nor agents. This simple, adequate, common law right any person or group of persons sui juris may exercise. The trustees issuing certificates of beneficial and capital interest divided into shares, as well as issuing bonds and other obligations as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. Italics, emphasis supplied in original, bold emphasis, and bracket information added. Okay. What becomes clear from this definition is that the express trust is not merely a property interest held by one for the benefit of another like any basic trust. Rather, it is a trust created by private contract for the holding of a divisible property interest, wherein the trustee is empowered by the settlor to do for a beneficiary of his, the trustee's choosing, whatever he may do for himself as an individual sui juris. What has been created here is a trust organization, lawfully by natural right. As a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorize another to do for him. Doing so requires no benefit, privilege, or franchise from any government or other outside party, and therefore the parties owe no duty to any government or other outside party to the extent that no common law, criminal, or civil wrong is the purpose of, let me see, what page are we on? Page 2? How do we get down there? We're on page 2, page 3. Okay, so let me see. Let me figure this out. There we go. The contract. When done properly, the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them Now, the question is whether the parties to the contract are truly acting sui juris. Example, of their pure, unadulterated common law and natural rights. Because if the parties import or associate benefits which grant an outside party a vested interest in the proposed contract, then the contract has acquired a third party overseer intervener. Declaration of the express trust. The declaration of trust is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration, so long as the word used make clear the settler's intent to create the trust or confer a benefit of some sort that would be best carried out in the form of a trust. A trust instrument doesn't necessarily need to be a declaration either, for a trust may be and often is formed out of a simple agreement or even a will. But with an express trust, the declaration has been preferred since the beginnings of trusts under the common law of England, which otherwise shunned fictions of law. This is where careful attention to detail is most crucial. Because in order to properly construe the intent of the settler, the objects, property, and manner in which all is to be carried out must set forth in unambiguous, precise language so as to particularly create the express trust. And where the intent of the settler is unclear, that would be ambiguous. Under equity, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid depending on the degree of ambiguity. Meaning, I don't know what you mean, ambiguity. It's not clear. What are you saying? That's what ambiguity is. It's not clear. However, when all is done properly, obviously, there can be no lawful impairment of the obligations of contract. Moreover, the declaration by its terms and provisions serves to establish the entire contractual arrangement, including the identities and positions of the parties, the trust's name, jurisdiction and situs, and all particulars of administration, all of which the courts of equity will fully support by the principle that equity compels performance. That is a maxim of law. Equity. Equity compels performance. I like that. Equity compels performance. All right. The ultimate result is the creation of a bona fide legal entity with its own separate and distinct juridical personality, with standing to sue and be sued. Gotta have standing, sue juris, and to function as a person in commerce by and through its trustees. Interesting. The term natural person has been applied to express trust by courts of equity because of its administration being carried out by men acting as natural persons. That's good to know. Right here. By men acting as natural persons. So I guess when you go into the court and you have power of attorney over that all capitalized name, you're acting as a natural person. Sui juris, you have standing that you could sue people. Because you are the executrix or executor of your express trust. Their trust would have been the implied trust, and they are the trustees of the implied trust of theirs. But we can go in as sui juris and the natural, acting as the natural person. Under this application, the trust's right of contract. What just happened? Where are we? The trust's right of what did I just do? Contract is alienable or alienable, whereas its creator's natural right of contract obviously is not. Wait, their contract, wait, the contract, I gotta go back so I could see what the first part of the sentence was. Okay, wait. So the term natural person has been applied to express trust by courts of equity because of its administration being carried out by men acting as natural persons. Oh, that's interesting. The term natural person has been applied to express trust by courts of equity because of its administration being carried out by men acting as natural persons. Oh. Under this application, the trust's right of contract is alienable, whereas its creator's natural right of contract obviously is not. Oh man, I hate that this thing is so touchy. It's ridiculous. Whereas its creator's natural right of contract obviously is not. So when the administrators in the courts do their express trust, which is implied, their contract is alienable or alienable. Their contract is alienable. Whereas its creator's natural right of contract obviously is not. Oh, I don't understand that, but it's good. That sentence is a good one to try to get. Let's keep reading and see if it explains this. Because like, if their creator's natural right of contract is not alienable, I don't know. The express trust nevertheless possesses inter alia the right to all enjoyments. That's what they've been doing, stemming from the contracts into which it enters, as well as all the obligations imposed under such contracts. The express trust possesses the ability to hold and own property, engage in business transactions, and incur liabilities, including tax liabilities, as well as assume creditorship, including secured party status, like any other legal person. I don't exactly know what this meant. So we're talking about the express trust that we want to do. Nevertheless, possesses inter alia the right to all enjoyments stemming from the contracts into which it enters, as well as all the obligations imposed under such contracts. The express trust possesses the ability to hold and own property, engage in business transactions, and incur liabilities, including tax liabilities, as well as assume creditorship, including secured party status, like any other legal person. Okay. So like the legal person is the all caps, but the express trust is kind of like that other all caps thing, because the express trust can do the same types of things that the legal person can. Apparently, this legal person is owned by whoever made it, and this express trust would be owned by us who made it. So in that way, we're the custodian or the guardian, I guess. All right, so the trust corpus. Corpus is like corpse, entity, dead body. The corpus is the body of the trust. Okay. The corpus is the body of the trust. Example, the property being held in trust for the beneficiary, the very subject matter of the declaration. That's my car, it's in a trust. That's my house, that's my dog, that's my child or offspring. I put it in the trust. It should be noted that virtually anything may be held in trust. However, there are certain things which, given their innate traits recognized in law, make for better subject matter, so to speak. You doing a pun intended there? Make for better subject matter. Initially, the legal minds who perfected the express trust in America did so to accommodate for the great obstacles in procuring special charters for corporations intended to deal in real estate, which trusts eventually came to be known as the Massachusetts Land Trusts. Massachusetts. Massachusetts. Look at this thing, it's touchy. It was when those individuals came to realize the immense benefits of employing the trust for the purpose of holding land that they eventually expanded their utility to include the holding of personal property. These eventually came to be known as the Massachusetts electric companies. Interesting. As an aside, when considering the presently hostile official attitude toward non-statutory trusts, what is interesting to note is that much of the express trust's perfection is attributed to Attorney General and later United States Secretary of State Richard Olney. But the fact that the express trusts were initially primarily utilized for the purpose of holding and handling real estate is very significant, especially to our present situation. Let's find out, what is real estate? The significance derives in pertinent part from the integral relationship between the law and the land. It is a fundamental principle of law that the land and the law go hand in hand. And in America, without the 14th Amendment, the law of the land is the Constitution with its common law principles and its substance of gold and silver. Referred to in this sense, precious metals are regarded in law as portable land. So if you put precious metals in your pocket, you'd be taking land around. Actually, we're considered land too. We are walking around real estate. The basic principle of law holds that land includes everything of value extracted from it. And without getting too deep into the operation of common law, it is this principle regarding the relationship of land and law which, by its operation, threw up an obstacle to corporate real estate ownership. In order to charter a statutory civil law entity to handle the substance of the common law, land, special, if not extraordinary, legal circumstances must exist. These circumstances did not exist prior to the post-Erie federal common law, whose imposition was made possible by the loss of the gold standard, the substance of the law, in 1933. Interesting. So the gold was the substance of the law, because up there it said about portable land and how gold and silver was portable land. So the gold standard, the substance of the law, because the law was the land. Right here. The relationship of land and law. Precious metals are regarded in law as portable land. These circumstances did not exist prior to the post-Erie federal common law, whose imposition was made possible by loss of the gold standard, the substance of the law, in 1933. A statutory entity is inherently accountable. This is different. A statutory entity, civil law, is inherently accountable to courts of civil legislative jurisdiction, deriving subject matter jurisdiction from the corporate charter, over which the legislature holds in rem jurisdiction, as well by way of possession of the charter documents themselves. So that right there, the statutory entity, that's your all caps name. It's the one that's accountable to the court's legislative jurisdiction. And the reason is because they are deriving subject matter jurisdiction from the corporate charter that they have, over which the legislature holds in rem jurisdiction. I don't know what in rem means. I guess I should probably look it up. I've heard this before. Oh boy, where are we? In rem. Here we go. In rem. Adjective, made against or affecting a thing, and therefore other people generally imposing a general liability. Compare with in personam. So in rem is an adjective in law. Made against or affecting a thing. Oh, so in rem is like bad. It's like not positive, it's negative. It's against and affecting a thing. Not that we are things, because we're not, but they made the name a thing. And therefore other people generally imposing a general liability. Compare with in personam. Wait, let me just look at what is actio in rem? Let's find out. What is that? Action in rem. Legal definition of action in rem: when there is a dispute related to a property title and the rights related to the title, the court will use action in rem. The term action in rem originates in Roman law. All roads lead to Rome. Proceedings in admiralty. Action in rem is closely related to maritime law. Oh, interesting. An in rem proceeding refers to a lawsuit or other legal action directed toward property. That's what it is. When we go to the traffic court or this or that, they're saying that we're property. Rather than toward a particular person, the action must be brought in the court, which has jurisdiction, as determined by the location of the property. Usually the property must be located in the same county as the court for it to have in rem jurisdiction. Whoa. I think my dog wants me to take her for a bike ride. Are you wanting me to take you for a bike ride or something? Guess so. This is good. We're on page 7 here. Wow, I just learned something about in rem jurisdiction. That's about property. Whereas an express trust is obviously inherently accountable to courts of common law and equity. Ooh, so an express trust is obviously inherently accountable to courts of common law and equity. Deriving subject matter jurisdiction from the trust instrument and corpus. As logic follows, in rem jurisdiction remains with the trustee at all times unless the trust instrument and corpus are surrendered to a third party voluntarily. In rem jurisdiction, actual possession is the key. That's good. That's really good right here. Hey, who's there? Who is in the room? Omi. I just learned something right here about in rem. That's amazing. In rem jurisdiction. In rem means property. So like when those courts, they have the all caps name, they're saying that they are the trustees of the property. So like when they're, when we're trying to do like the courts of common law and equity, we don't want to be in rem. We don't want to be property. That's why you have your own, you express the trust, and that's how you get equity right there. So deriving subject matter jurisdiction from the trust instrument and corpus. So it says, as logic follows, in rem jurisdiction, we don't want that, remains with the trustee at all times unless the trust instrument and corpus are surrendered to a third party voluntarily. In rem jurisdiction, the example is actual possession is the key. So that's amazing. That's property in rem jurisdiction. I just read it. That's so cool. So we'll have to like look up. Let me look up in personam for a second. Okay, because I just finished reading in rem jurisdiction. I'll read it again. In rem jurisdiction is a legal term describing the power of a court may exercise over property or over status against a person over whom the court does not have in personam jurisdiction. Jurisdiction in rem assumes the property or status is the primary object of the action rather than personal liabilities not necessarily associated with the property. So we should probably look up in rem some more and read that so we can understand. An in rem proceeding refers to a lawsuit or other legal action directed toward property. We're not property. Rather than toward a particular person. The action must be brought in the court, which has jurisdiction. As determined by the location of the property. Usually the property must be located in the same county as the court for it to have in rem jurisdiction. This is why when you go to court, they say, what's your, state your address, your name and your address, because they want to claim in rem jurisdiction over you. That's why they do that. If you're saying that you're from their county, they'll be like, okay, I'm the trustee over that property of that slave in my county. Okay, got it. So let me just look up in personam for a second, because it's different. In personam. All right, in personam. This has been helpful. I recorded this and I'm gonna put this up so everybody can follow. In personam is an adjective in law made against or affecting a specific person only, imposing a personal liability, rights and duties in personam. In personam jurisdiction. And Hamilton talks about acting in personam. What are some examples of in personam? An in personam criminal forfeiture judgment was also entered against him. This is using it in a sentence. 2 of the defendants filed motions for dismissal for a lack of in personam jurisdiction. Here's another usage in a sentence. Any judgment will affect only the property seized as in personam jurisdiction is unobtainable. Let me read that again. Any judgment will affect only the property seized. As in personam jurisdiction is unobtainable. Action in rem means property, is an action separated from the action of in personam. Interesting. What does jus in personam mean? Let me look that up. Jus or jus? Jus in personam, J-U-S. Let me read that one. This is very interesting. Hey. Googling. So in personam is a Latin phrase meaning against a particular person. In a lawsuit in which the case is against a specific individual, that person must be served with a summons and a complaint, E&W, known as particulars of claim, to give the court jurisdiction to try the case. And the judgment applies to that person and is called an in personam judgment. Interesting. Okay, so this brings us to today. In the jurisdiction of the 14th Amendment, United States Public Trust. Oh, precious metal. Oh, the substance of the common law is legally merely a commodity. So, like I had heard that this 14th Amendment thing, we don't want to be claiming to be a 14th Amendment person because the 14th Amendment was never ratified. They didn't have all the states to actually pass that. That's what I had heard. So in the jurisdiction of the 14th Amendment, United States Public Trust, public is not private, precious metal, the substance of the common law, which is precious metal, by the way, is legally merely a commodity. Whoa. So here we go. Back in the Republic, however, it remains the staple for payment of debts, though surface gold and silver are in considerably lesser quantity and without a fixed standard upon which to be traded. Let me go back. The express trust under the common law holding real estate, silver or gold, is holding the very substance of the law under which it was created, thus ensuring that bond between law and land and the powers and guarantees that come with it. Interesting. Certificates. What may come as a surprise is that any trust may divide its trust property into shares and issue certificates. Yep. The power to issue certificates and bonds and employ the use of an official seal never has been restricted to corporations. Wow, that's good to know. It is well settled law that whatever else most corporations possess beyond their artificiality and right of suit in a corporate name is mere incident or consequence of incorporation and not a primary constituent. In fact, most attributes now commonly held as corporate in nature, such as the power of issuing transferable shares, limiting liability of officers, using an official seal, making bylaws, purchasing lands and chattels, are merely the legislative recognition and adoption of natural common rights any man or woman sui juris may exercise without permission, much less a charter from the state. That's awesome. The court in Warner v. Beers clarified this principle most effectively. So what that's basically saying right here is about certificates is that any trust can issue property and shares. You don't have to be incorporated and you don't have to be part of the state. You don't have to have a charter. You can issue any. So right here, there are several very useful and beneficial accessory, also spelled accessory, powers or attributes, very often accompanying corporate privileges, especially in moneyed corporations, which in the existing state of our law, as modified by statutes, are more prominent in the public eye. and perhaps sometimes in the view of our courts and legislatures, than those which are essential to the being of a corporation. Like everybody sees, Microsoft or Costco or all those other in the public eye, that they're all prominent. But right here, such added powers, however valuable, are merely accessory. They do not in themselves alone confirm a corporate charter and may be enjoyed by unincorporated individuals. Yay, that's us, unincorporated individuals. Such a power is the transferability of shares. Such too is the limited responsibility or liability. That's good news. So too, the convenience of holding real estate for the common purposes. That sounds great. Exempt from the legal inconvenience of joint tenancy. Ooh. Or tenancy in common. You know how when you purchase property, like wait, where did I just, there it is. You buy a house or something, and then they tell you that you're a joint tenant with your spouse. That's what they're saying right here. So we too can get real estate for the common purposes and exempt from the, ooh, this is good, exempt from the legal inconvenience of joint tenancy. Ooh, that's really good. That's going to help me. Again, there is the continuance of the joint property for the benefit and preservation of the common fund, indissoluble by death or legal disability of any partner. Every one of these attributes or powers, though commonly falling within our notions of a moneyed corporation, is quite unessential to the legality of a corporation, may be found where there is no pretense of a body corporate, nor will they make one if all were combined without the presence of the essential quality of legal individuality. Italics and bold emphasis and bracket information added. So how I was reading this was that these attributes or powers of having a trust, though commonly falling with our notions of a money corporation like Amazon or Costco or something, is quite unessential to the legality of a corporation, may be found, we can have one too, where there's no pretense, like you're pretending of a body corporate, nor will they make one if all were combined without the presence of the essential quality of legal individuality. The trustee of an express trust is empowered by the terms and provisions of the trust instrument to issue certificates not only of beneficial interest, but also of capital interest. That's wonderful. Generally speaking, beneficial interest is that which is held by the beneficiary or beneficiaries of the trust, who is entitled to a certain proportional share of the trust assets during the life or at the termination of the trust. Cool. While capital interest is that which is held by the exchangers who has invested property into the trust and thus becomes entitled to a certain proportional share of any profits and assets remaining at the termination of the trust. I had a trust made, and it's an irrevocable trust. And I have shares in there and bonds, certificates, and they go to my grandchildren and my children, and each one of them have like 1/5 or whatever it is. And, those companies like Amazon and Microsoft or what have you, they also, when they start their corporation, they're incorporated, by the way, LLC, which is limited liability. They also come with certificates that they can fill out, and they can sell shares of their company. But this over here was saying that it's not limited to those things like we see in the public. It's not limited to over here to corporate in nature. So we're unincorporated. That's what this was all saying right here. So let me move on. As a rule, the terms and provisions of the trust instrument control the manner in which beneficial and capital interest are to be administered. So, you know, like when we have given notice to say that we realize our name was made as a trust and that other people are administering it or maybe not even taking care of it, that's the one